Hello, 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 everybody. I hope you are having a wonderful day on purpose. September 11th, 2024. 20, September 11th, 2024. Now, I know that the 11th is etched in many of our minds for a main reason when America was under attack. Who remembers that? If you're here in the room right now, let me know. If you're catching this on the replay, let me know. Let me know where you were. I was at work. And I was working at the Kennedy Center. The Kennedy Center in Connecticut caters to adults with developmental delays. I was to be their medical person, taking them to every doctor's appointment, scheduling all follow-ups, getting all of this. I was medication certified, so I would have to order prescriptions from the Kennedy Center pharmacy, ensure that the meds were available and ready for in-house use, as well as out when they needed to go out with their families. On September 11th, I had just dropped all of the adults off at the workshop. The Kennedy Center in Connecticut has a workshop. It's somewhat of a place where their clients who live in their homes and also some who don't can participate in daily activities to allow them to have a sense of normalcy. It's almost like they have a job. They don't get paid a whole lot. However, it's so rewarding to them. Something to a lot of them are like, oh yeah, I'm going to work. And I had just dropped them off, and I got back to the group home in Fairfield, Connecticut, and my boss, Heidi, she said, come in here, Danny, come here, quick. Come in here. I said, what's going on? And we saw on the news the Twin Towers crashing down. I think it was the first tower, the first plane, and then the first tower. And then the second tower. And it was just chaotic. And I stood there frozen because I couldn't believe what I was seeing. And they were reporting that this was real time in New York. Now, mind you, New York was only 45 minutes from me, from where I lived in Connecticut and Bridgeport. So it's a hop, skip, and a jump. And I also knew people who worked in New York. So 9/11, I don't think in my lifetime I've seen a bigger tragedy than that attack. But guys, I hope you're having a good day on purpose. Let me know where you were on 9/11 on that fateful day when terrorists attacked the United States. Excuse me, guys. So Today I wanted to come to you and talk to you about Carly Gregg. This case is quite concerning to me because of the age of the defendant, um, versus as well as the charges. Carly Gregg, at the time of this crime, was 14 years old, and she's from Rankin County, Mississippi. She actually appeared in court yesterday. She did. She appeared in court yesterday on a few motions, and I'm going to read this article to you guys. It says, we'll hear motions on Tuesday before the trial is set to begin for a teenager accused of unaliving her mother. Rankin County Youth Court prosecutor Corey Gerber testified that Carly Gregg, who was 14 years old at the time, tested positive for Mary Jane when she arrived at the Youth Detention Center. Gregg was taken there before she was moved to the Rankin County Jail. Prosecutor Catherine Newman said Gregg admitted to smoking Mary Jane on March 18th. That is the day of the pum-puming of her mother. And Ashley Smiley. Her mother, Ashley Smiley, which took place on March 19th. So she's saying that she smoked Mary Jane on the 18th, which would be the day before she pum-pumed her mother. Carly is currently charged with the M-word and attempted M-word to stand trial September 16th. She is also accused of pum-puming her stepfather, who survived. Also, during Tuesday's hearing, Judge Dewey Arthur granted a gag order motion against Gregg's attorneys that was filed last month by prosecutors. The motion claimed that defense attorneys have willfully violated the Mississippi Rules of Criminal Procedure. According to prosecutors, defense attorneys were told that they could not comment on facts of the current case against Gregg to the media. In August, Gregg stood before a judge and rejected a plea deal. Now, they tried to come up with a plea, I think, if I'm not mistaken, and don't quote me here because I'm just now looking at this case, but if I'm not mistaken, they offered her something like 30 or 40 years. And she rejected that deal. The 15-year-old, who is charged as an adult, is being held in solitary confinement in the Rankin County Jail. And we just went over the case and the charges that she faces. But the charges that she faces could end her up getting life in prison. Now, a grand jury previously indicted Gregg on the counts of first degree unaliving, first degree, the M word, and attempted M word, and tampering with evidence. The pum-puming happened just after 5 p.m. on Tuesday, March 19th, in the 200 block of Ashton. During her last appearance in court on September 10th, the court denied the motion to transfer Carly Gregg's case to Ute Court. They spent some time on the issue of reliability of the drug screening conducted for the defendant. Now, guys, we're going to go ahead and get into her appearance on July 23rd, 2024. And then we're going to get into her most recent appearance, which was yesterday. Guys, if you haven't done so already, this would be a good time to smash that like button for me one time. I definitely want to create awareness regarding these cases. I don't think a lot of where these children, for whatever reason, are unaliving their parents or other individuals within unity. In the case of Colt Gray, if you guys haven't heard of Colt Gray, he's another 14-year-old in the state of Georgia who's facing a multitude of charges because he chose to go into his school with a pum-pum and unalived 2 teachers and 2 students. So it's just, there's something going on with these children in this country, or these parents in this country. You know, we can have a little bit of a conversation after we watch these proceedings, because I definitely want to talk about it. To me, how are these children, one, getting access? How are they getting access? Why are your arms, your pum-pums, parents, grandparents, aunts, uncles, why are they not secure? And I mean, we know yet at 14, you should know better. You know it's not a toy. But you know what? We're going to talk about it. Let's get into this hearing.
To exclude the public and media, NBC number 12, the defendant submitted a motion to exclude the public and the media. NBC number 35, the courts read and considered all the motions and responses, including Court TV and Great Media and Incorporated DBA WLBT's motion to intervene and oppose. NBC numbers 19 and number 56. Primarily, the defense raised 99-43-101. There's a one-sided case of that. That's Pitts versus State, which was tried in this very courtroom. In that case, it was the witness was a victim of sexual assault. If I remember correctly, it was her father. Courts looked at 99-43-101. In particular, the courts looking at subsection B, subsection I. It says any criminal hearing, criminal trial, or other criminal proceeding in the circuit county court in which a child testifies as a victim of a crime or as a witness to a material issue. right to an open and public trial is a shared right. It's a shared right of the accused and the public, and the common concern being fairness. This court is required to determine whether the rights of the accused override the qualified First Amendment right of access by the media and the public. First is First Amendment to the U.S. Constitution is the fact that the government shall make no law abridging from the press. Testing witnesses' statements is to require a public statement under oath, facing penalties for perjury. This court is being asked to exclude the public. First is court. This is the public's courtroom, not this judge. No, this court exclude the public. Second, the court is being asked to exclude media. What the court has heard is that the arguments are that the family's tragedy is not fodder for public entertainment. I agree, it's a terrible fact of humanity. I don't know why people are interested in cases sometimes, but they are. Back to Oedipus, King Oedipus, the Greek story, to William Shakespeare, and what the 16th century people have been interested in jury trials. In this country, we have the media, we have the press, so things can't happen behind closed doors. As far as the impact on the family of the victim, this court often is faced, the defense counsel doesn't want the family having an impact on the case, because if the family's calling for sentencing, for blood, then the defendant doesn't want blood. However, when you have a family that's calling for mercy, I don't know what to do in this particular instance. However, it can't be done behind closed doors. Just can't. As far as heightening scrutiny on potential jurors, the interveners have agreed, and this court will order that the jury list will not be released. In this case, it will be placed under seal. If any potential juror at the close of this case wishes to be identified, that individual juror can step forward on. However, if the individual juror does not wish to be identified, then the list of the jury will be sealed, and that juror will not be identified. Further, the rules of electronic proceeding, the Mississippi rules for electronic photographic coverage provide that the jury is not to be videoed in any manner. There's not to be any still shots of the jury. The court will not allow the cameras in during jury selection. Bottom line is the court is not going to allow the jurors to be identified. The intervener has agreed to that. As such, that is an accommodation this court is making to alleviate the defendant's fear. However, as far as live streaming conversations of defendant and her counsel, the rules specifically provide that there should be no audio recording.
Do you guys realize that a jury of her peers, okay, so a jury of your peers, albeit that she's being tried as an adult, is the jury going to be comprised of individuals her age? I have to look that up and see how they handle it. Because a jury of her peers would be a bunch of teenagers.
Of the defendant and her counsel. Of course, I heard any evidence that that's happened. In fact, the court has heard exactly the opposite of that. Additionally, this court has taken some steps. The court has told the bailiff that a room behind the courtroom will be available to defense counsel and the defendant during breaks, where they can sit, they can discuss trial strategy, they can have those conversations. Anything that a camera could pick up, a jury could pick up visually during the course of the trial. However, the court will impose certain limitations on the press in regards to audio recording of statements between counsel and between defense counsel and the client and the defendant. All right. The court's made some other accommodations to lessen any potential impact on this defendant. The court has allowed defense counsel to provide her with clothing that is not jail-issued clothing. And the court has ordered has spoken with the sheriff's department, and they understand that she's not to be shown visible restraints from today forward. In fact, she was not shown any visible restraints today. All right. After reviewing the motions, the responses, and the hearings of arguments of counsel for both sides, the court denies the motion to exclude the media and the public in cases number 12 and 35. The court finds the following restrictions and/or alternatives to closure will ensure both an open and public trial and that the defendant receives a fair trial. Therefore, is ordered and judged that the location of equipment and personnel necessary for electronic media coverage of judicial proceedings shall be in place either inside or outside the courtroom so as to be minimally intrusive to the proceedings. Only equipment
Okay. So that's about it. So the judge will be allowing cameras in the courtroom for this one. So I hope that Law Crime picks this up. Hey, Libby Lou, good afternoon or good evening or good morning or good night, based on wherever you're tuning in from. Hey, Kaya and Kayla's mom. Oh, you were driving your 18-wheeler on 9/11 when that tragedy happened. Man, I am telling you. The next video that I want to share, well, hearing, I should say. Now, guys, don't be alarmed. My icon may or may not go away. Let's see what Restream wants to do today. Usually, once I share one video and then I go to share another one, it removes my icon. I don't know why. Sure why, guys. Excuse me. A second, guys. I'm trying to get this. There we go. And then my icon stayed. Hey. I don't know. Restream felt like leaving it alone today. So, guys, this is her court appearance from yesterday.
And I was like, you need to get it together. And I just sort of didn't do it.
It's a lot of money. It's a lot, yeah.
Lunch. And so I was like, I didn't take down like that tree's gonna fall on my house just because I didn't do what I was.
Yeah. They're trying to have a little chatter in the courtroom before they get started and before the judge takes to the bench.
That's what I'm waiting on. We've gotten several quotes, but we haven't gotten the best.
So this is actually one of the cool cameras right here. When we get through, we did the last one. I changed the SD card and this copy of the SD card. Yeah, who wants?
How are you guys doing today? I didn't ask. How are you doing, Liddy Lou? How are you doing, Kaya and Kayla's mom? How are you doing, Bush babies? Just checking in on my strong friends while we wait. I'm trying to see if I could fast forward this. Hold on, guys. This is pretty dangerous for me to do this. But I like living dangerously. Okay. It's like so many minutes before they bring her in. I'm sorry, guys. I didn't know that this video was going to be like this. It's crazy. Okay, so they bring her in. It's still on silent. Give me a second, let me skip to where they bring her in. Give me a second. Oh my goodness, my computer is going crazy. My computer's going. Okay. 1 second, guys. Right here. There. They bring her in. Why didn't she rise up?
We're here by way of pre-trial conference. Well, we're dealing with docket number 168. State filed a motion limiting to exclude motion of punishment. The defendant filed no response. Granted. Give me an order to that effect.
Yes, sir, Your Honor. One question regarding that punishment as well. The attempted murder statute requires bifurcation for guilt and sentencing. And of course, we would ask that any comments about sentencing be reserved for that, for the murder and the attempted
For
murder.
the sentencing phase, yes.
Yes, sir.
All right, docket number 169, motion in limine to exclude the overruling jury nullification arguments. No response was filed. It's granted. State's giving an order. All right, motion, document number 170, motion in limine regarding facts not in evidence. No response was filed. Granted. Give me an order. Document number 171, motion in limine regarding speaking objections. No response was filed. Motion is granted. Document number 166, motion to suppress urine test. Heard from the state. I've read the state's motion. I read the defense's motion. I read the state's response. State's burden of proof. Do you have any witnesses you wish to call?
I'm sorry, Your Honor.
It is the state's burden of proof. Does the state have any witnesses it wishes to call?
Sure, Your Honor. The state calls Corey Gerber.
All right.
So they're trying to suppress her urine, her positive urine test.
I do.
Her defense.
The you understand the surrounding regulations for this?
I did. You know,
If you would introduce yourself for the record.
my name is Corey Gerber.
And, Mr. Gerber, what is your role currently?
I currently serve as the Rankin County Youth Court Prosecutor.
As a youth court prosecutor, do you have experience and information regarding what happens when an inmate is intaked at the juvenile detention facility?
I do.
And is there a policy and procedure put in place regarding drug screening of all offenders once they're taken into custody?
It is the practice of the juvenile detention center to drug test everybody that is brought in. That is my understanding.
And to be clear, could you explain for me kind of the breakdown out at the juvenile detention center? There is the youth part, the court part, of which you're a prosecutor, and then there is the detention part. Is that correct?
They're two separate entities. The juvenile detention center is run by the sheriff. The Rankin County Youth Court is the court, and they are separated by locked doors. We are two separate entities. Yes.
Hold on just a second. Let me check. It's on my.
Testing.
Mr. Gerber, you said that each inmate is drug screened at admission. Could you tell the court what's the purpose of those drug screens?
My understanding is that every child detainee that is brought to the juvenile detention center is drug tested for the purposes of safety. There are multiple things that are done when a child is brought in. One, they are to meet with a mental health crisis assessor. The other is they are drug tested. And my understanding is that they are drug tested just to make sure that whatever substances are in their body for purposes of medical care.
And are you familiar with the drug screening that's done in conjunction with that?
I am.
Could you tell the court about that?
So those are observed screens. Those screens are taken. Once the screen is done, they are presented to the lab. Then the lab would run those tests. The lab is on site. That is a very expensive piece of machinery. I'm not an expert in how that machine is run. I can tell you that that machine is calibrated once a week. Every time that the machine is started before any tests are run, there are controls that have to pass. You have 3 attempts to pass those controls. If the controls do not pass at that time, the machine has to be recalibrated until the controls do pass. Otherwise, we do not run tests.
And Mr. Gerber, do you have any personal knowledge about whether or not that machine was running appropriately on March the 20th of 2024?
I do not have any personal knowledge other than if it wasn't running appropriately, it would not have been running.
So they would not have performed a test if it was not working appropriately?
They would not have ran the test if it was not working appropriately.
You talked about that there are some checks and balances in place and calibration to make sure that the machine is running correctly. How reliable are the results from these particular drug screens?
They're very reliable. If they weren't reliable, we wouldn't use them. We wouldn't waste anybody's time or money doing the tests. I will say they are not confirmed tests. So typically what you have is whenever a urine test is had and you get a result, if that result is a positive test, what would typically happen in a case like that is that urine would be sent off for confirmation. We do not do that. We use that test primarily for assessment, not for any evidentiary value. We are not presenting that information to the court without some other types of discussion.
And so the screening's done for safety. The screening has some checks and balances in place. And you said that the results are very reliable. So if someone had presumed tested positive during one of those screens, like the defendant did in this case, that would be very reliable.
It would be reliable. If there was any question, typically what we would do is send that person for a separate test. Depending on what you're testing for is going to be, there are some things that we test for that are not as reliable as others. An example would be methamphetamines. Those are the ones that we typically have the question on. We do send those. We don't send that urine for confirmation. Instead, what we do is send the person out to give a dollar sample and have that sent for confirmation.
Court's indulgence. Mr. Herbert, with regards to the test performed by Carly Gregg, has anyone provided you anything to show that that particular test was not reliable?
I don't recall seeing that test, nor has anyone mentioned that it wouldn't be reliable.
Okay, question.
Thank you, Your Honor. Now, Corey, okay, why was Carly at the youth detention center to begin with?
Under federal statute, a child cannot be detained in an adult facility without an interest of justice hearing being had within 6 hours of that child being detained. So as a courtesy to the judge, Carly would have been at the juvenile detention center until a hearing could be scheduled for purposes of that interest of justice. She was there long enough for that hearing to be scheduled. She was transported from the juvenile detention center to the jail here or to the court. I'm not sure where she was sent after that, but that hearing was scheduled.
Okay, so, because court, she, according to the statute, she's considered an adult, correct?
Yes.
Okay. And so, my understanding, why is it that everybody is tested in the, I guess, in the youth detention center? Isn't there some federal grant that y'all are under that requires that?
I'm not certain whether there's a federal grant that requires everybody to be tested or not. Again, my understanding is they are tested out there for purposes of safety issues, safety reasons.
Okay, so she was only going to be held there for a few hours until she could be brought over here to Rankin County. Is that
As
correct?
soon as the hearing could be scheduled, correct.
Okay, and so there wasn't a warrant or anything like that to have her do this test, correct?
Not that I'm aware of.
And there was no probable cause where somebody was saying that we want this test done, correct?
I'm not certain. The only thing I can say is that she was tested for the same reasons that anybody else that would be brought to that detention center was tested for.
Okay, but she was an adult and everyone else would have been children, correct, or youths? Okay, correct.
She would be classified as an adult. She's still a child.
Yes, I agree with you. She's still a child, but she would have been classified as adult.
Yes.
Okay. And so now when you were talking about the test itself, and you said that it's calibrated once a week. Okay. Is there a logbook that you have that says that it's calibrated?
I don't calibrate it. I just know that the protocol of practice is that it is calibrated once a week, and that's going to be the first start, typically on Monday.
So you don't know if these things are even kept. Is that correct?
Oh, I don't know. I don't. I'm not the person running the machine.
Okay. And the night that this happened, who ran the machine?
I have no idea.
Okay. And if I showed you the test card, would you be able to tell us who ran the machine?
Yes.
Okay. Yeah, approach the witness, John.
It's show it to counsel. Anything we're going to show the witnesses for.
Okay, Sarah.
Can you mark that P1 for identification?
Yeah, that's the test card that we have. In fact, that's the only document that we have concerning this test.
This is the only document. There's no there's no back sheet to this.
That is the only document that we've been presented.
Then no, I can't tell you who ran the test.
Okay. From looking at that document, can you even say that it's calibrated or it's been checked or anything?
I can't. Not from looking at this document, no.
Okay. Now, I guess, once these samples, these samples are given, you said they're taken to the lab, and the machine's in the lab, is that correct?
That's correct.
And then they're run at that, the samples run at that point.
It is run once the machine is started. So, a better answer for your question is that if the sample's taken at night, and it's placed in the lab would be started by a person that runs the machine when they would get there the next morning, and then it would be ran in. So I don't know what time this was taken. I can tell you the date that it was taken based on this. It was collected on the 20th, according to this sheet, and it would have been ran the same day at 9:21.
Okay. And when these samples are, I guess, run, what happens? I guess, is there going to be extra fluid, or is it marked and then it's put in the? I guess you'll have a refrigerator or something.
So yes, that we do have a refrigerator, but no, the extra fluid is disposed of. We do not keep the urine, not to my knowledge.
Okay, so you run this test. So let's get back to this where you say you use the test for, because the test is for the youth court, basically. Is that correct?
Well, it depends on the case. I mean, yes. I mean, if this child were to be a child under jurisdiction of the youth court, this test could be used for multiple things. One, to give the detention staff an idea of what is in that child's system for purposes of maintaining the child at the juvenile detention center. The second could be for purposes of disposition. The youth court is a court of rehabilitation, and we want to address the whole child. So if I see this particular test, I can tell you that it's positive for cannabinoids in an amount of 237.7 nanograms per milliliter with the cutoff of being 20. That would indicate that this child has consumed some type of cannabinoids. We would want to know that moving forward for purposes of A&D assessments and possibly enrolling them in some type of program to address cannabinoid use. If there is a question as to whether or not this is accurate, what would happen at that point is we would send that child for something else. But these tests are reliable; they're just not confirmed. So there is no. I would not use this as an evidentiary test.
Right, and that's what I'm getting at, is an evidentiary test to say that is actually what it is. That's not what you use them for, and that's not what they're designed to be used for, correct?
That's not what I use it for. Again, this is just an assessment tool used by the court for purposes of disposition. In the event that there's no contest between the child or the person, the donor, sometimes adults get these tests. If there's no contest about what is found in these tests, at that point they can be submitted to the court. But I do not submit these to the court for evidentiary value.
They're trying to argue this point. I'm not sure why they don't want her drug screen to be included in the evidence presented at trial. But, I mean, it wasn't like she was on meth or, like, can I say meth on here? I don't know. YouTube gods, forgive me. It's not like she was on a heavy, strong opioid. She just smoked a joint probably with her friends. And it was the day before the unaliving of her mother. So it wasn't like she smoked and then boom, just something set her off. No, she smoked the day before, and then the next day in the evening, 5 p.m. Eastern Standard Time, she pumed her mom. I'm going to give you guys a little bit more information on some of the details that have been circulated out as well regarding this particular case after this. So you guys stay tuned, replay gang. Please be sure to weigh in the comments. I want to hear from you guys too. Bush babies, you guys can weigh in on the comments, but I'd really prefer that you subscribe to the channel and set your notifications to all so that you're notified when I go live or add new content. That's what I'd really prefer.
And adjudication.
And so where we're at right now is, you said they're calibrated. There's no calibration documents or anything that I provided you or that you have in front of you, correct?
I don't have it. If you haven't provided it.
And I think the only thing I gave you is a test card that was given to us.
That's correct.
Okay. And so that doesn't tell who did the test. It doesn't say if the other safeguards had been done on the test. It is the person even qualified who ran the test? We don't even know that, do we?
I will tell you that there are only certain people that are allowed to touch that very expensive machine. They are all qualified to run it. But I can't tell you who did that particular day. As to your other question, it was collected by someone in the Rankin County Sheriff's Department. So that would be a detention staff, but I do not know who that would have been. That information can be gathered, but I don't have it.
No further questions, Chairman.
Can we make the exhibit with my full order?
Yes. I'm trying to steal your exhibits.
Read it.
Raise your arm. Mr. Gerber, as I understood it on cross-examination, you said these tests are for, again, safety and medical purposes for the detention staff as well as the donor.
As well as disposition. In the adult world, that would be sentencing. We want to make sure that we have all the information available to us to make sure that the rehabilitation process happens. So they have multiple uses. Yes.
When the detention center finds someone is tested positive for a substance like Ms. Gregg did in this case, why is that important for them to know from a safety standpoint?
Well, for example, if it had been fentanyl, we would have taken the child directly to the hospital. The other is we want to make sure that there's no interaction with anything else that's going on. I don't work in the detention center. I don't want to speak for them, but I mean, I think it's fairly obvious that we want to know if the child is under the influence of any type of drug while they're in the detention center.
And if the child admits that they've used drugs, would that tend to corroborate the test results as well?
Yes.
Do you have any information that Ms. Gregg did not corroborate this test as you sit here today?
No, I don't have any information.
No further question, Your Honor.
Stand down. Statement, call us next witness.
No further witness, just argument, Your Honor.
Defense have any witnesses that wish to call on this issue?
No, Your Honor.
All right, argument by the state.
From here, the voting, Your Honor. The state outlined in our response and then filed an amended response. I want to bring that to the court's attention. Initially, we believed that the Juvenile Detention Center was under a particular grant through the OJJDP, which is the Office of Juvenile Justice and Delinquency Prevention. That federal grant does require drug testing. Upon communications with the Board of Supervisors, it's actually a different grant than we initially cited in our response. So I did file an amended response attaching the appropriate grant that does in fact require drug screens of all offenders at entry. Or that does require, drug screens, as well as the Rankin County Sheriff Department's Juvenile Detention Center Policies and Procedures 2.2F. Those were provided to me by the Sheriff's Department, which again outlined that each offender is screened there at the detention center immediately. It also outlines the policies and procedures that are to take place upon entry. These screens, as you heard from Mr. Gerber, are very reliable. The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least. We believe that this information is certainly pertinent since she has asserted her right to claim an insanity defense. As this court's well aware, in cases such as Crawford v. State, once the defendant puts their sanity at issue, the door is thrown wide open for the admission of evidence of every act of the accused's life relevant to the issue of insanity or sanity and is admissible in evidence. That's Crawford v. State. 867 Southern 2nd, 196. Additionally, Mississippi Rules of Evidence 703 state that an expert can rely on facts and data that are not necessarily admissible in evidence. And so our doctor, Dr. Pickett, has relied upon Carly's admissions of using marijuana as well as this presumptive test to show that is and does call into question her mental state. As this court is also aware, voluntary intoxication is not a defense to murder. It does not entitle you to an insanity defense. And so we believe that 703 as well as Crawford and the admissions by the defendant make this test even more reliable. This isn't just a piece of paper that shows that she had marijuana in her system. We have the defendant herself saying that she'd smoked marijuana at or around the time of the crime, as well as additional witnesses that we intend to introduce. As outlined in our arguments, we also believe that this urine screen is akin to the DNA buccal swab found in Maryland v. King. There was a 3-part test. We believe that it's similar in that the Rankin County Detention Center's booking policies require that all offenders be screened, that urine, and also that urine sample is the least and minimally invasive drug screen that at the time. And as such, also is cited in our arguments. Gerber talked about today that these tests are done for the safety of both the offender as well as the facility. And we believe that that record is actually a part of Carly Gregg's medical records. And because of that, and because of her claim of insanity, she has waived all medical privilege with regards to anything that might have to do with her mental state at the time of the crime. Specifically, we cite to Rule 503F of the Mississippi Rules of Evidence, as well as the cases outlined in our response. We ask that the state be allowed, that our evaluating psychiatrists be allowed to review and talk about the results from this urine screen as they do affect the defendant's mental state at the time of the crime. And then additionally, we would argue that if a search warrant was required, Holloman v. State would apply. In this case, it was a drunk driver who killed someone driving in a car. Law enforcement was on the scene. They observed the presence of beer cans, empty syringes, and bottles containing unidentified liquids. At the time, the person's blood was drawn, and also a urine sample was taken. There was the presence of methamphetamines and cocaine. This sample was taken without a warrant, similar to what we have here, and the court found that a warrantless search is permissible in certain exigent circumstances if it can be shown that grounds existed to conduct the search that, had time permitted, would reasonably have satisfied a disinterested magistrate that a warrant should be properly issued. And similar to Holloman in this case, the substances that were in Ms. Gregg's system at the time can dissipate over a period of time. And this screen was done on the 20th. She was brought over hours later. And we would argue, Your Honor, that if a warrant was got, if we had received a warrant, had to serve it on her and get an additional sample, that would be even more far removed than this sample was on the 20th rather than the 19th at the time of the crime. We would, of course, also state that, as pointed out, it's going to come into evidence that Ms. Gregg was using marijuana. And we believe that if it doesn't fall under the warrantless search and for the safety and within her medical records and the alternative, the state would argue that this would fall in the inevitable discovery doctrine. And admittedly, under that doctrine, you have to show that law enforcement, there was some misconduct, and that but for the misconduct, these items would have come forward. There's been no such misconduct in this case. However, there is a test that outlines when things would come into play if it was inevitably discovered. And we believe that's the same thing with this urine screen. Based on admissions by the defendant as well as other evidence, law enforcement had at the time in their possession illegal substances, the presence of the vape pens that they had seized from the house, and knew of the fact that there may be a potential for drugs to be in her system. We would certainly ask Your Honor to consider all of those exceptions and rule that the urine screen would be admissible for its purpose of showing that marijuana was in fact in her system and not for a quantitative study.
Response. Thank you, Don.
First of all, I'm just going to briefly touch base. The state brought up the fact of basically the indigent circumstance where you can draw blood. The Supreme Court of the United States changed that in McNeely, Missouri versus McNeely in 2013. You now have to have a warrant. So when the state's saying that you do not have to have a warrant in that type of, like in the hallway situation, that was a different time. That was okay at that time. That would have been under the Shoemaker ruling that said that there were exigent circumstances and that you could get away with not having a warrant. That has now changed. The one thing I'm going to say is that with this charge, Carly was charged as an adult, and she was taken to the youth detention center, and it puts her in a different status than most people that are going to the youth detention center. Most of the people that are going to the youth detention center are being handled as youth. In fact, I would say all of them except a very small, minute amount. In Carly's situation, she's entitled to due process, which is there has to be a warrant, there has to be probable cause, there has to be some of the protections built in. They bring up the Maryland v. King case, and they say, well, in Maryland v. King, there was actually a state statute that mandated certain testing. And the Supreme Court was looking to see if that was viable, if that was a viable law. And they came back and they said, yes, that there was it validated the law. It said that there was a judicial reason for them to have the law, to have the testing. So therefore, what they did in Maryland versus King was okay. That's not the type of situation that we have here. There is no Mississippi law. There is no federal law that says that this shall be done. This is just the policy and procedure of the Rankin County Detention Center. And so what's happened is she's entitled to due process, and that didn't happen in this situation. There is no probable cause. There is no warrant. That was testified from the stand. The next thing that I want to bring up and put to the attention of the court, in order for a test to be valid, you have to have the person, and this is under Mississippi law, and this is any of these chemical tests, you have to know who the person is performing the test. You have to know the testing procedures. It has to be laid out somehow, and it has to be presented to the court and say, hey, this is done. And then the last thing is there has to be something to show that it's reliable. The way they show that it's reliable is having calibration records. You have the information of who did the test, how it was done, when it was done, and it was done according to the way the test was supposed to be carried out. We don't have any of that. The only thing that has been presented to us is a one-page paper, and on the bottom of the paper, it's document 1 of 1. It's not 1 of 10 or something like. There's a whole bunch of other documents that go with it. You have a test card. The other thing that comes into play is the state is wanting. They say, well, first of all, the test is not designed to be a standalone test. It is not to say what you're seeing in that test is what's in her system. It's only an identification test. They use it for that purpose. They do not use it for evidentiary purposes. What the state's wanting to do is take that test and then turn it into evidentiary purposes. They say, well, we just want to have it as like an identification kind of thing. Well, no, they're wanting to, in their reports, they're going in and trying to say whether or not she's under the influence at the time based upon that test, which is an invalid test. It does not show, it doesn't meet any of the requirements of being a valid test at the, by how it was done, who did it, was it calibrated, did they follow the protocols? None of that stuff. None of it has been provided to us. And also, there's been no consent. There's been no testimony that there's no consent. No consent, there's no warrant. The test wasn't done. It's being used for a different purpose than what the youth detention center uses it for. For all those reasons, Your Honor, we ask that the test be excluded at this time.
Just making your reply.
Thank you, Chairman. Now, I believe that Missouri versus McNeely deals with warrants for blood draws, and in this case, we're talking about a urine screen. Also, Mr. Camp mentioned the laws in Mississippi and the statutes about calibration, and I believe what he's referenced it to is the implied consent law, which talks about intoxilizers, not the drug urine screens. Again, we believe that this does fall within the exceptions as cited in our amended response and also argued today. And more importantly, we believe that it falls within Ms. Gregg's medical records upon which she's waived any privilege to, as well as under Rule 703, and that our expert should be allowed to rely upon the presence of marijuana in her system at or near the time of the crime, including the day after the offense, to render his opinions regarding her mental state at the time. We ask that the urine drug screen not be suppressed in its entirety, Your Honor.
All right. This court looked at several different cases, in particular Skinner, Von Rath, Vernonia, Maryland versus King. In addition, the court also read Chandler versus Miller, Ferguson versus City of Charleston. In this particular case, because the need for a warrant is greatly diminished here, where the arrestee was already in valid police custody for a serious offense, supported by probable cause, the search is analyzed by reference to reasonableness, not individualized suspicion. Reasonableness is determined by proclaiming the promotion of a legitimate governmental interest against the degree to which the search intrudes upon an individual's privacy. Or we find that the government has there's a legitimate governmental interest in determining whether or not somebody is under the influence in the juvenile detention center, not for the purposes of prosecution, but for the purposes of safety of the accused. Obviously, like Mr. Gerber testified, if somebody tested positive for fentanyl, there are serious withdrawal issues. Well documented. It's not hard to find that out there. I'm not sure the Juvenile Detention Center is equipped to handle those type of situations as a valid governmental reason. Looking at Skinner, Von Rath, or Vernonia, the court believes that falls into that. Additionally, the court looked at Jones versus State, Mississippi case cited 881 Southern 2nd 209. The physician-patient privilege was waived in this particular case. And in Jones, the evidence was actually used to prosecute the person. That was not the intent of this evidence. The intent of this evidence was to find out whether or not there was a critical medical need that needed to be assessed at that moment. Now, the court would have a different, if the state was saying to offer this to prove possession of cannabinoids or some other crime, but that's not what it's being offered for. In retrospect, the state was able to go back and look at that and raise it for the defendant's insanity defense. So for those reasons, in the case law cited, Maryland versus King, the court also found that a urine analysis is the least invasive and most reliable method to obtain a drug screen. A needle would be very invasive. Buccal swabs are not considered to be very reliable. The saliva type of testing. Hair testing is invasive. You're removing a piece of hair from the child's body. And in addition, the reliability of those in short periods of time are not where they need to be. So it shows too great of a window. So for those reasons, the court is going to deny the motion to suppress. However, the court is going to restrict the statement not to get into this in your case in chief. It can only be used if and when the defendant raises an understanding defense. That'll be the court's rule and states to give me an order. All right. Next matter was a motion for gag order document number 177. The response was filed late. As such, it will not be considered. Motion for gag order is granted. Give me an order. Next motion is document number 175. Motion to enforce the court's previous orders and compel the motion eliminating to exclude evidence not previously discovered, produced and discovered. Again, the response was filed late. Document number 174, motion eliminating to exclude insanity defense, to exclude testimony of Dr. Gerald O'Brien, Dr. Mark Webb, and Dr. Clark. Again, there was a late response filed. However, we're going to have to deal with the issue of late file discovery, so I will hear it all at once. State's motion, I'll hear you out.
Court's indulgence, I'm trying to read it.
Once she's getting that together, for the record, even though the responses were filed late and the others, I did read them before I ran the section. All right, you can see.
And I'll start with our motion to enforce the court's previous orders to compel and motion limited to exclude evidence not previously produced in discovery. This court entered an order directing both parties to exchange discovery that was in their possession at that time by August the 20th, 2024.
I think I actually worked y'all do it 2-3 times before.
That's correct, Your Honor. The last order regarding discovery said that all discovery within the party's possession, there was also an in-court hearing regarding that, was to be turned over or the possibility to be excluded.
All right, let's go.
So
What are you trying to exclude? Which witnesses?
yes, sir, Your Honor. So as of August the 20th, 2024, the state had 0 witnesses from the defendant and or any substance of their testimony. So we filed this motion on August the 30th, asking that pretty much any evidence that they sought to introduce at that point be excluded because we had received none. So to be clear, the defendant had dropped off an external hard drive, a jump drive at our office. It contained photographs. It contained an investigative journal by someone by the name of Amber Floyd. It did not contain anyone's testimony, anyone's information, and we were not provided the substance of anyone's testimony. During that same meeting, this was plea negotiations. The state had offered and asked, and quite frankly begged, for the names of anyone who would provide any information regarding the defendant's potential mental state at the time. We were not provided that information. However, the defense attorneys told us during that meeting that they knew the names of several teachers, as well as had a statement that the victim, the living victim in this case, Heath Smiley, had prepared, where they had sent him questions and he responded to those questions in writing, as well as other witnesses. We asked that that be turned over on that day. It was not. We've asked that it be turned over subsequent to that, and it was not until September the 3rd that the state received a list of witnesses from the defendant. And I apologize, Judge. May I get that?
You have a copy of it?
Yes, sir.
Of the list you received?
Yes, Your Honor.
she is not playing any games with this case. I like the prosecutor. Very even tone.
On September the 3rd, the state was emailed a witness list that contained the name of Heath Smiley, stating that his proposed testimony would regard his personal knowledge and observation of the events on March the 19th, 2024, his relationship with Carly's mother, Carly's relationship with Heath, Ashley Smiley's mental and physical state, which we've been provided no documents to that effect, Carly's behavior and mental health issues from the fall of 2023 through the present. At this point, we still have not been provided any documentation, any statements, anything regarding any mental state other than the records that we've requested from 2023 outside of Mr. Smiley's interview with law enforcement on April the 4th that we provided. Additionally, it says that he will talk about the investigation in this matter by the Sheriff's Department as well as the Rankin County District Attorney's Office. Essentially, Vicki Breland has pretty much the exact same substance of testimony. That is the deceased victim, Ashley Smiley's mother. Next witness is James Daniel Floyd. He is the brother-in-law of the deceased victim, Ashley Smiley. We have no substance of his testimony other than he will testify regarding his personal knowledge and observations regarding the events on March the 19th, 2024, and the investigation by the Rankin County Sheriff's Office. No information provided by him other than that, with the exception of contact information. BG, who the state has interviewed, and SR, who the state has interviewed. Next, they list a Shira Higby. It is believed that Ms. Higby is a teacher and that this is one of the individuals, again, that the defendant knew about far in advance of August the 20th, as well as Tricia Gilbreth. Again, it appears to be a teacher of Carly's that the defendant knew about far in advance of August the 20th. The next name, Dr. Andrew Clark, which he was not retained before August the 20th. So, of course, that was not in their possession at the time. We have a separate motion regarding Mr. Clark. And then Corey Garber, which we do not object, of course, to the testimony that he provided. But certainly, so we're asking that any testimony that Mr. Smiley is called to testify about outside of the two statements that he's provided to law enforcement in this case be excluded. We ask that any testimony by Vicki Breland regarding anything at all be excluded, that the testimony of James Daniel Floyd regarding any type of testimony be excluded, that BG, anything outside of the interviews that he's provided to our office be excluded, and those have been turned over to the defense, as well as SR. Same thing for her. Our office provided statements to them, recorded and typed up interview notes. And then we're asking that Shira Higby, Tricia Gilbreth be excluded. And of course, we asked separately that Dr. Andrew Clark be excluded. But those were all people that were in the possession of the defendant prior to August the 20th, 24. In addition to...
Hang on, so we leave that. Do you have a copy of the witness list?
Yes, sir. Ma'am, Price.
Mark S.
Your Honor, for the record, I want to show it to them. I have the email where it was sent September the 3rd at 4:15. Our office. Never seen. We, of course, outlined our arguments within our motion as to why we believe that those witnesses should be excluded. I mean, first and foremost, the fact that they violated this court's multiple orders regarding discovery, that by their own admission, they had this information and for whatever reason chose to wait till September the 3rd to produce it. There's no good reason other than willful conduct for them to have done such. There were multiple conversations between the state and the defense about turning over this information. This is not new information. This is not something that wasn't in their possession. This is something that we certainly believe is akin to a willful attempt to hide evidence. We ask that each of those witnesses, with the exception of Mr. Smiley, and the testimony that he's previously provided to law enforcement, be excluded. Would the court like for me to proceed with regards to our other motion in limine for the experts?
No. Any further argument as to these witnesses?
No, sir.
I'll hear the response.
Okay, so they're arguing. They're going to argue the point of the evidence for a little bit, but ultimately the judge my icon go away. Your icon went away. I don't understand how this happens all the time. At any rate, guys, they're going to argue these points. However, the judge is going to ultimately deny their request for the motions to suppress the urine test. That's not going to be suppressed. The judge is going to allow the prosecution and like I said at the top of this young lady is facing life in prison. They did offer her a plea deal, but she rejected that deal. So I will be following this case. This was just a motions hearing. I'm trying to figure out exactly when her court date is, but it's been hard getting information on her because Rankin County, let me make sure you guys can hear me. Okay, now you guys can hear me. Why was it doing that? I'm listening to it, guys, in my headbuds. But in Rankin County, Mississippi, of course, they don't have online services. So I am going to work on getting a copy of the arrest affidavit and the indictment by way of snail mail. So we'll go over the indictment information once I receive it in the mail. Okay? All right, y'all. So that's all for today. I hope you enjoyed the content and find interest in this case as much as I do, because I don't understand what's going on with our children. I really don't know what's going on with our children. As I said at the top of this as well, I do recall being young. I do. I recall being young. I recall wanting to have things my way. But I could never imagine unalive parents. I want to know what's going on in 2024. We have Colt Gray and Libby. Thank you for pointing out the fact that the father is very much culpable for her son's crimes because he purchased the Pum Pum as a present for his son. So he already knew, based on the investigation that the FBI did with them May 23rd, 2023. And then December, that very same year, that Christmas, he purchases his son a Pum Pum. He is responsible, and I hope that he gets every bit of that time. Now, as far as this mother, I don't really know. Like I said, I'm just finding out about this case, just doing my research on it. So I will come back with updates and additional information. But how or why did she feel it was okay to touch a Pum Pum at 14? It's just, if you guys have children, young children, teenagers, and you you actually have your Second Amendment, you know what I'm saying? Lock it up. Lock it up. About responsible Pum Pum ownership. That's a conversation to be had. And I hope you guys are having it. All right, y'all. I will be back very, very soon with a case update show to update you guys on a few of the cases that I'm following. And I've also presented here on the channel. Guys, if you're not already subscribed to the channel, go on ahead and subscribe today. Set your notifications to all so that you're notified when I go live or add new content. All right, guys, until next time.